And good morning, everyone. I'm Ariane Aaron Bureau here at our digital desk with Alaska's news source, where we're about to listen in to hear from Alaska Deputy Attorney General John Skidmore. He is planning to discuss the procedural steps taken by the Office of Special Prosecutions when it reviews officer-involved cases, shooting cases rather. He's also going to address the appropriate timing for release of evidence, such as the body-worn camera footage, and is also going to provide an update on the status of all pending officer-involved shooting cases. Right now, we do have our investigative reporter Johnson Kuhn there with our photojournalist Peggy McCormack, where we will listen in. There looks like they're just getting ready to set up at the podium. Again, if you're just joining us, we are going to listen in and hear from Alaska Deputy Attorney General John Skidmore. The Department of Law sent out this press release that they're going to have this conference today. He is planning to discuss the procedural steps taken by the Office of Special Prosecutions when it reviews officer-involved shooting. So let's go listen in, and of course, if we don't have anyone at the podium, we'll come back and recap and let you listen in until we do. So let's take you out there now. And again, it looks like they're trying to get set up here, so we'll just kind of talk to you here for just a bit. We'll let folks come on. We are live here on our Facebook and also on our YouTube pages. Again, Ariane Aaron Bureau here at Alaska's news source from our digital desk. We got this press release today from the Department of Law. This is regarding the law's procedure after officer-involved shootings. We're going to hear from Alaska Deputy Attorney General John Skidmore. He's going to discuss those procedural steps that are taken by the Office of Special Prosecutions. So anytime there is an officer-involved shooting, that case always gets reviewed and sent to the Office of Special Prosecutions. We're going to hear what happens when it reviews those officer-involved shootings and the steps in the cases that's involved. This is at the fifth floor conference room. We do have our investigative reporter Johnson Kuhn there, so we'll of course have more on that tonight during our later newscast. Of course, you can always stay up to date with information on our website as well at alaskasnewssource.com. So we're just standing by to wait to hear from them if you're just joining us to hear from this. And also, we're told regarding this press release that Alaska Attorney General Treg Taylor will also say a few words to open the event. So we'll take you back here. Pause it just a little bit. Looks like they're not quite set up and ready to go. Of course, as soon as they step up to the podium, we'll bring you in and let you listen in. In the meantime, though, we'll just hang here. But please stay with us here as we have this press conference that should be starting here in just a bit. And it looks like they're now at the podium, so let's take you there and listen in. And it looks like we might be having an audio issue. Just stand by with us. We're going to try to get that worked out in just a bit here.
At risk our ability to carry out justice. If we fail to uphold the constitutional rights of an individual, we jeopardize our very ability to hold that individual accountable for any crimes that they have committed. Here to describe that process in more detail is John Skidmore, Deputy Attorney General. John? Thank you.
So good morning. My name is John Skidmore. I am the Deputy Attorney General for the Criminal Division for the State of Alaska Department of Law. Officer-involved shootings are an important subject. They're an important subject that deserve the attention of the public and also deserve careful review of those incidences. Special Prosecutions, or the Office of Special Prosecutions, is a subdivision or an office within the Criminal Division that I oversee. And among the types of cases that they handle are conflict cases. Conflict cases meaning those involving politicians, that involve employees from within the department, that would involve police from around the state. These are but some of the cases they handle, as they're also handling things like sexual assaults, sexual abuse of minor, homicide cases from out in rural communities. They also handle all cold cases in the state. So officer-involved shootings are just part of their portfolio, if you will, but an important part. And when we look at these officer-involved shootings, the first thing to know is that there is no state law, no state statute that requires such cases to be referred to prosecutors. Law enforcement need to refer criminal cases to us. Not every officer-involved shooting would be criminal, and so they're not required to refer those to us in any way. Yet, despite the fact that none are required to be referred to us, since 2009, every single officer-involved shooting in the state of Alaska has been referred to the criminal division. 2009, when I was the head of the Office of Special Prosecutions, we implemented that policy, and we've maintained that policy ever since. The types of cases that they review, or the type of review that they are doing, is to determine whether or not that shooting violates the criminal law. When we talk about violating the criminal law for a shooting, we're typically talking about homicides or assaults. What the review is not meant to do is it's not meant to cover the policies of the individual agencies. Those policies will vary from agency to agency across the state, and our job as prosecutors is not to evaluate their policies and decide whether or not their use of force was in compliance with their policy or their training. Likewise, our review is not meant to be an evaluation of whether or not there is civil liability for an officer or an agency based on that use of force. Our sole purpose is to decide, did they violate the criminal law? That's what we as prosecutors are tasked with doing. Now, if you allow me to describe the process from the Office of Special Prosecution's point of view, what you have in these situations is you have the law enforcement incident occur, and the law enforcement agencies respond to that incident and begin the investigation. Part of that response includes them contacting the Office of Special Prosecutions. In Anchorage, for example, our Anchorage DA's office, every time there's a homicide, the Anchorage office is notified, and we have a prosecutor who goes out to the scene and works closely with investigators from the very beginning. That same model is followed in a number of other offices around the state for homicides, and for officer-involved shootings, we try to do something similar. And so when there is an officer-involved shooting, the Office of Special Prosecutions is notified, and from the very beginning then, they are tracking that case and they are communicating with the investigators that are involved. If it's possible to go to the scene, then the prosecutor will go to the scene to be able to see it firsthand. In Anchorage, where most of our prosecutors are located, that's easy to do. In some of the rural areas, it's a little more challenging, but there are times when our folks from Special Prosecutions are even able to travel out to those rural communities to see those scenes as well. In addition to reviewing the scene, they also want to be participating in the interview process. That is, when the witness officers are interviewed and when the officers that have discharged their firearms are interviewed. That's a role that our folks can actively observe and can suggest line of questioning to those individuals in law enforcement conducting the questioning. To be clear, our folks, our prosecutors, are not conducting the questioning. They are not conducting the investigation. They are, however, advising. And that advice can include things like providing advice on search warrants to ensure any search warrant that's obtained meets all the appropriate guidelines and that it's done properly. The last thing that we would ever want is for an officer-involved shooting to result in criminal charges only to have some portion of that investigation be thrown out because it didn't comply with the law. That's the last thing we want. If we have an officer that's violated the law, our first and foremost interest is to see that individual is held accountable. And everything we do is geared towards that purpose. Now, once the investigation is completed by the law enforcement agency, our folks then have to review that investigation. What does that look like? Well, anytime that you have an officer-involved shooting, I shouldn't say anytime, most of the times you have an officer-involved shooting, there is an autopsy report that needs to be looked at. Not always is the person killed, sometimes they survive. Obviously, there's no autopsy, then it's medical records. There are ballistics. Ballistics are important for things to help us determine which firearms were discharged. Were the shell casings found at the scene consistent with the discharges that we believe happened and which bullets match up to which guns. In an autopsy or other medical records, we're looking for the cause of death or the cause of injury. We want to look at toxicology. We want to look at how many bullets struck an individual and where they struck them. Entry, exit wounds. All of those details matter. Those reports from experts are important for our review to make sure we get things done correctly. We're also interested in the scene diagrams, in reviewing the audio recordings, any 911 calls or dispatches that may have come in, any radio traffic that led up to the incident and occurs after the incident is over. We're interested in any audio recordings of contacts with witnesses and video. Of course, we're interested in video. Dash cams, body-worn cameras, security footage from businesses, cell phones of private citizens that may have captured things that would be helpful or relevant for us to view. All of that information is important for us to be able to review to make sure that we have all of the facts to ensure that we make the right decisions. Now, in conducting the review process, there are some basic principles of criminal law. These are things that I assume most of us are already familiar with, but let me cover them briefly because they matter as they're the starting place for the review that's conducted by our folks. The first is that in the American legal system, you have the presumption of innocence. We start with the presumption that an officer who fires a shot did not commit a crime. We then have to go and look at our burden of proof, which is to prove every element beyond a reasonable doubt. Why do we have to do that? Because that's part of the constitutional rights for due process for all defendants. Beyond that, if we fail to prove those beyond a reasonable doubt, then an individual is acquitted. And the way that defendants generally defend cases is they argue, hey, there's insufficient evidence, it wasn't me, there's some defense that might be available to them. Defenses come in two flavors. The first is a defense in which the state, the prosecutors, have to disprove it simply because the defendant claimed it. The second one is called an affirmative defense. Those are defenses where the defense carries some burden of proof. Justification, the type of defenses that we're going to be talking about, are the first category, not the second. That is, the prosecution bears the burden of disproving beyond a reasonable doubt that justification was appropriate in those cases. Now, officer-involved shooting cases also involve something different than most criminal cases. We are talking about a public servant who, from society's standpoint, has been given certain powers and authorities. We task them, we ask them to enforce our laws, and as a result, we give them certain powers to detain, to arrest, to terminate escapes. They are given authority to use force that the rest of us do not enjoy because we have asked them to engage in those very specific activities. Normally, the interference with somebody's liberty would be a criminal violation, but for law enforcement, it is not. The justification excuse for public duties that we give these government officials ensures that they are not held criminally liable when they are exercising the power and authority that we have given to them. Now, all of this means that at the end of the day, this is just about the criminal law, and it's important to remember that all citizens still have access to sophisticated processes of criminal appeal, and there are also civil claims for damages when those are appropriately warranted. These are just some of the other considerations that we have to look at. Let me shift and talk about the laws governing shootings. Homicides, assaults, I've listed for you here some of the basic elements of these. The mens rea, whether it's intentional or knowing, a dangerous instrument is always going to be a firearm, serious physical injury or death typically are always associated. And then we have, I'm sorry, I didn't advance the slide there, let's do that. And then we have the justification defenses, self-defense, defense of others, and the one that matters most in these circumstances, which is what I talked about a moment ago, and that's the authorization for the use of force in making or terminating an arrest. I want to get into the specifics of those to make sure that we're all clear on what that means. Alaska Statute 1181-370 talks about non-deadly use of force by law enforcement. And this is for any time that they are going to make an arrest, to terminate an escape, or to detain somebody. And in these circumstances, the officer is authorized, when and to the extent that the officer reasonably believes is necessary, they can use non-deadly force to do all of these different things. Now, non-deadly force is not an officer-involved shooting, but I start with this statute because it establishes the foundation for what we're going to go to next, and that's the use of deadly force. Deadly force is found in Alaska Statute 1181-370, and in this one, officers are justified to use deadly force when they reasonably believe it is necessary to make an arrest or terminate an escape in one of three circumstances. The first is that the individual they are contacting has committed a felony use of force, not a misdemeanor, but a felony use of force against another person. The second is that there is an escape in which the individual that is escaping is in possession of a firearm. Again, a second situation in which they are authorized to use deadly force. And the last, and perhaps one of the more common areas, is when the individual that they are contacting is endangering life or poses a serious risk for inflicting serious physical injury on another person when not arrested without delay. These are the circumstances in which our laws have authorized officers to use force. Now let me pause for a moment and point out these are laws for the state of Alaska. I cannot tell you what every law says in the other 49 states. I often get those sorts of questions when I talk to the legislature. I do not know the laws of all the other 49 states. I'm telling you what our laws in Alaska authorize. When we talk about law enforcement's use of deadly force, there's a couple other things that are important to know. The arrest or the stop must be lawful. So the authorization for officers to use force isn't for them to just carte blanche go out and do whatever they want. It has to be when there is an arrest or a stop, and it must be lawful. And also to be clear for everyone, the use of force is not talking about preparing to use force or threatening to use force. That is not considered deadly force in this specific circumstance. For other citizens, that would be. For officers, it is not. So they can draw their firearm. That's not deadly force. It's only deadly force when they are discharging it. All right. So what does all this mean? Well, it's really the balancing of a couple of different concepts if you look at it in a different way. It's two competing societal interests. The ultimate seizure, that is seizing someone's life, versus public safety. This is the conflict. This is the tension that arises for law enforcement and what we ask them to do on a daily basis. So let's talk about the release of evidence in criminal cases, because we know that law enforcement's use of force can be controversial. Citizens want to know what happened. And in fact, over the years, as technology has advanced, obviously one of the things that's come about is something called body-worn cameras. That's a camera that's attached to the officer's uniform and is supposed to be capturing what is happening for them in their context on an ongoing basis. This allows people later on to review that footage and to help us evaluate what transpired in that particular case. But think about this for a moment. How many times have you seen a prosecutor from the Alaska Department of Law release the evidence in our homicide cases prior to trial? I hope the answer is never, because if we did, we'd have been violating that person's constitutional rights. We are required to protect constitutional rights of everyone involved in a case. If you look at the United States Constitution's Fifth Amendment and the Alaska Constitution's Article 1, Section 7, that's where you're going to find the right to due process. This is where it says that no person shall be deprived of life, liberty, or property without due process of law. Due process of law under the Constitution and under the Sixth Amendment and under Section 11 of the Alaska Constitution talks about having the right to an impartial jury that decides when we will take someone's liberty from them. It also entitles individuals to be able to confront the witnesses brought against them, to call their own witnesses, and to have an attorney help them in all of these proceedings. That's what we're trying to do in a court of law. But if we release information prior to being in a court of law, what's the likelihood that the jury who shows up and has to evaluate that case is going to be impartial? What's the likelihood that they have not already begun to make up their minds because we've released the evidence ahead of time. There's a phrase, a cliche. It's called trying your case in the media, and it's actually against the rules. You're not supposed to do it. I can tell you that if we as prosecutors were to do that, we would be disbarred. We would lose our licenses to practice law. That's how significant and important this concept is. And so it creates a tension without question. A tension between the public, who wants to have transparency, who wants to understand what government officials have done, with our obligations to protect constitutional rights. Let me talk about the ethics rules. The Alaska Rules of Professional Conduct 3.6. These are the rules that control how lawyers behave. And 3.6 talks about trial publicity. It says that lawyers are not supposed to make statements outside of the courtroom about the case. This is the rule that says you're not supposed to be trying the case in the media. Now, do we make press releases? Do we come and talk to you all about when cases are filed? Of course we do. The rule specifically allows us to make certain statements, but not make other statements. And so if you go through the things that you're allowed to do, and these apply to all lawyers, not just prosecutors. This is all lawyers. Any civil case as well, you're not supposed to try it in the case. So they can do things like they can talk about the identity of the people involved in the case. They can talk about information in the public record. They can talk about the fact that an investigation is in progress. They can talk about the scheduling in the litigation. They can talk about a request for assistance in obtaining evidence from the public. These are all acceptable. And you can warn of danger. But you're not supposed to release all of the other evidence in the case. And specifically, subsection 7 there goes into that for a criminal case. But in addition to 3.6, our rules of professional conduct have a rule that is only for prosecutors. Because prosecutors have such great discretion, and because prosecutors are the ones that can bring the type of case that causes someone to lose their liberty, because it can infringe upon an individual's constitutional rights, whether under the federal constitution or the state constitution. There's an ethics rule that applies exclusively to prosecutors. And it says not only are we not supposed to make those statements, but we also have an obligation to try and prevent those people whom we work with, investigators, law enforcement, any employees in our office. We are to do everything within our power to constrain all of those individuals from not making the type of statements that we ourselves would not be allowed to make. Why? Because doing so deprives an individual of a fair and impartial jury, and that deprives them of their constitutional rights. And we have an obligation to protect those for everyone. I would be remiss if I didn't point out that under our state statutes there is also a crime for intentionally interfering with someone's constitutional rights. Alaska Statute 1176-110. Subsection A3 says that a person commits the crime of interfering with constitutional rights if under the color of law, ordinance, or regulation of this state or a municipality or a political subdivision of this state, the person intentionally deprives another person of a right. If you deprive a person of their right to an impartial jury, you've committed this crime. So, let's talk about that tension that I mentioned a moment ago. That tension between the public's desire to know what's going on, to have transparency, because they are entitled to know those things about their government, without question. And I wouldn't want anyone to think that the Department of Law opposes the public's ability to see body-worn camera footage or other evidence from an officer-involved shooting. That is not the position of the Department of Law. Our position is that the evidence can be released once our review has been completed. To do it prior to the review, you run the risk that charges are filed against an officer and we deprive that officer of their constitutional rights. Or, conversely, you could have a scenario in which we're not charging the officer, but we're actually filing charges against the individual that was fired upon, they survive, and they themselves were committing crimes. And the body-worn camera footage or other evidence from this particular incident now implicates that person's constitutional rights to a fair trial. Everyone is entitled to have their constitutional rights protected. So, how do we go about trying to help the public get the information faster? I'll be the first one to tell you that I think that our process of reviewing these cases has had some problems. There are cases that we have reviewed that it has taken us in the Department of Law far too long to review. And so, just last week, I met with the Office of Special Prosecutions and I assigned twice as many prosecutors to be handling these cases. We went from 3 to 7. That ensures that our reviews are done in a more timely and expedient manner so that the review can be completed and so that the evidence can be released more timely. Victims' families, the public, they deserve to have that information. We want to get that to them as quickly as is appropriate, but we also want to make sure that the review that's done is a thorough review. You'll note in the press release that we've sent out, we've described the status of officer-involved shooting cases. There are 3 that were recently released. Some of them took longer to get to the conclusion than they should have. One happened in October of 2023, and we just issued the declination letter on July 15th. That took way too long. We don't want that to continue to happen. The others occurred in February or in June of this year, and both of those letters were released in July. The February one, again, took longer than I would have liked. The June one, that was a pretty fast turnaround. If you look at the cases that are still pending, I'm going to go through them in the order of the age of the incident. We have one case that occurred on November 1st of 2023. Obviously, we're here in July, and we haven't been able to issue a letter yet. Why? We're still waiting on the ballistics report. I went through earlier and described the type of information that's important. Ballistics are a key component for us. We need to have that report to complete our review. And when we get it, we will issue the letter, hopefully, shortly thereafter. The others have all occurred in 24. May 13th, we're still waiting on an autopsy report and, the autopsy report and ballistics, this is for the Christopher Handy case, were just provided to us yesterday. It'll probably take us a couple of weeks to finish that review. But the ballistics and the autopsy were just given to the Office of Special Prosecutions yesterday. That's why we haven't issued a letter in that case yet. That's why the evidence hasn't been released publicly yet. Once we have a chance to review those reports and finish our overall review of whether or not charges should be filed, then we'll know either A, we filed charges, or B, we didn't, and therefore the evidence is appropriate to be released. There's another one that occurred on May 18th. We're still waiting on the ballistics report. One that occurred on, now I have a series of 5 of them that have all occurred during the month of June or July. And for the ones in June, we're still waiting on ballistics and autopsies. And then for the ones in July, for one of them, the individual's still alive, so obviously not an autopsy report, but we haven't even received police reports in those cases yet. So you understand, we want to get our reviews out as quickly as possible. To help make that happen, we're also working with our partners. We have commitments from the law enforcement agencies that we work with to provide us the materials, their investigations in a more timely manner. I know that they will do that. They've committed to me that they are going to. In addition to that, we've also had meetings with the labs, the crime lab here in Alaska, to ensure that we can get the ballistics reports more timely as well. We're going to try and help narrow down which ballistics reports are needed and which are not, because waiting for those reports causes a delay in our review and being able to release the information. So we are in communication with these other partners to try and make these things happen faster. And last but not least, we've also been in communication with the State Medical Examiner's Office. We in the Department of Law don't supervise them, we don't control them. They are, however, our partners. We work with them, and we are improving communication with them to try and make all of these cases move more quickly so that we can have an appropriate balance between the public's desire for transparency with ensuring that there is a thorough review and ensuring that citizens' constitutional rights are protected. I want to thank all of you all for being here today. I hope that going through the list of cases helps answer some questions that are out there. I'm also at this time willing to take questions from folks in the media if there are any questions about officer-involved shootings that I can answer. I will tell you at the beginning, I'm not going to talk about specifics in any case other than what I already have. You're welcome to ask me the question, but I will likely refer back to my ethical obligations not to release information that's not already in the public eye.
Thank you, John. How about first up, Johnson Hume, do you have a question? And I'm going to hand you the mic so folks at home can hear.
So I'm sure you're aware of the efforts being made by the Assembly and APD to draft new policies around body-worn cameras and releasing footage. You know, I'm new to Anchorage, so I'm still trying to catch up on things, but I believe under the Unified Home Rule, municipality can sort of establish its own policies, and you know, despite what policies the state might put forth. So I'm just wondering how you might feel about some of these efforts being made. I mean, they're talking about releasing footage within 45 days and having a 14-day period during which families can sort of request to view that footage. It sounds like that kind of, to some extent, flies in the face of the state's policy regarding releasing footage.
So what I can tell you is that, yes, I am aware the municipality is having conversations internally right now about how they want to manage their policies. That's really for the municipality to decide what policies they want to adopt and how they're going to do it. I have seen a draft of the policy that APD has. I note the 45 days. I also note that information can be delayed in the release if it would violate a constitutional right. How they choose to implement those things, what policies ultimately adopted, I really have to defer to the municipality on those things.
Just a quick follow-up. Do you ever feel exceptions should be made in terms of releasing footage before prosecution, before an investigation's conclusion?
I don't believe that information should be released to the public. If you're asking me, is it possible for a victim's family to be able to view some footage? That's possible. But would I think that release of the video itself to the family, that is, here's a copy of it, that wouldn't be a good idea, because then you run the risk that someone else now is going to post that publicly, again, interfering with that ability to ensure there's an impartial jury. So allowing someone to view it is different than giving them the footage itself. But if your question to me is, do I ever think there should be an exception of releasing footage to the public prior to a charging decision? The answer is no.
What if there was a hypothetical scenario where, say, surveillance video from a neighbor, you know, showed footage of the incident that appeared to contradict the story put forth to police? I mean, you know, for the sake of clarifying things for the public's sake, I mean, would that ever be something you could see releasing footage ahead of time?
I think when there is footage that is possessed by private citizens, whether it's companies or individuals, if they have footage that they think bears upon an incident, whether an officer-involved shooting or otherwise, I would hope that they would come forward and bring that information to the Office of Special Prosecutions. They can bring it to the investigators themselves, but if for whatever reason they're not comfortable with that and they wanted to bring it to us directly, absolutely. We want to review all of that information and all of that footage to make sure that we make the right decision. Is releasing it to the public necessary for us to make the right decision? No, I don't think it is. If you provide it to us and allow us to include it in our analysis, that's what's most important. Making it available to the public afterwards, I fully support that.
Thank you, Johnson Kuhn at KTUU. The next reporter we'll go to is Zach Hughes if you have a question at the Daily News.
Zach Hughes with ADN. It's a bit of a two-parter, and the first is just how unique is Alaska in having a state entity that's looking over kind of local jurisdictions that kind of initiate these reviews? I mean, obviously we're not NYPD or anything like that, but it just strikes me, I mean, is it unique that we have kind of dual entities involved in this process?
Okay, so part one, this is part one, right? The answer is that it's very unique, because in Alaska we have what's called a unified system of criminal justice. We are only one of 3 states in which the Attorney General's office actually has all the prosecutors within their office. Most other states, the other 47 states throughout the United States, prosecutors are elected officials, and it's county by county. And in each one of those prosecutors' offices, they could have different policies. Beyond that, you also have law enforcement, courts that are county by county, district by district, that can change. So Alaska is very unique in having a unified system. From that standpoint, I think it's extremely unique. There's only 2 other states that have a unified system, but in those, I can't tell you what their laws are, and I can't tell you that they review all incidences. In 2009, prior to 2009, I've been in the department for 25 years. And in my time in the department, it used to be that the local district attorney's office would review officer-involved shooting cases. We changed that in 2009 under the direction of the then Deputy Attorney General and Director, with my support, because we wanted to have a unified process. We wanted everyone to be treated the same all around the state. So we consolidated all of them into special prosecutions. And I am not aware of any other state that has a similar method of saying every single officer-involved shooting will be reviewed, and it's going to be reviewed by this one office. So I think those are pretty special things that we have. It's not required in our statutes, but it's a policy that the Department of Law implemented and that we've stuck by for over a decade now. And I think it's done a tremendous justice and service to the citizens of the state of Alaska. And I would hate to see anything jeopardized.
Well, and so the second part of this question is just, I mean, how have other jurisdictions, and maybe it's apples and oranges if you're talking about kind of large cities or, county level government, but how have other departments and other investigating agencies squared this circle or kind of balance this tension between constitutional rights on the one hand and the public's push for transparency? I mean, because there are some jurisdictions that have pretty quickly released body cam footage. I think Chicago right now is kind of at the vanguard on some of that with citizen review panel. I mean, is your determination that these are not good balances of kind of constitutional protections, or we're just kind of operating in our own world and it's not even worth the effort of trying to compare?
Yeah, no, that's a great question, Zach, and I appreciate you asking it. The first response, or the first part of the response is that I don't know what the ethical rules are in the other states. I don't know what their statutes are, so I can't comment on what those constraints are. But if you ask me as a general policy, and I don't know what Chicago's doing, but let's take a hypothetical. If Chicago is saying, when there's an officer-involved shooting, we're going to take that body-worn camera footage, we're going to give it to the media, and we're going to allow it to be posted online so that everybody can review it, I think that's a bad idea.
No, but I don't think anybody's doing that. I think
And that's where my point is. That's what I don't think can happen. If you're saying there's a limited number of people that can review something, that's not the release of the footage to the media and the jury pool at large. That doesn't violate then someone's constitutional rights. If there was a citizen review board that was sworn to not release the information and to hold that information confidential, to allow the process to go forward, I think there are ways to still protect individuals' constitutional rights. So again, it's difficult for me to comment on a Chicago or a Los Angeles or a New York because I don't work in those communities. I don't know what their laws are, I don't know what their rules are, and I don't know what their policy or practice is in those situations. What I do know is I can tell you what's very clearly written in both the US Constitution and in the Alaska Constitution. And I can tell you what our laws say, and I can tell you what our ethical rules are.
Okay, next reporter up, Wesley Early with Alaska Public Media.
Hey, thank you. So I'm curious, you mentioned since 2009, the Office of Special Prosecutions reviewed every officer-involved shooting.
Yes.
Do you happen to know offhand how many of those have been reviewed for criminal charges?
Yes. There have been 148 since 2010. I apologize, I don't have the statistics back in 2009 on the sheet in front of me. That I have them somewhere, I just don't have them with me. But since 2010, there have been 148.
That were referred to and that people went to trial over.
148 instances in which officers discharged their firearms, and those cases were sent to the Office of Special Prosecutions for review.
Right. My question was, how many times have those reviews sort of led led to criminal charges being filed?
We have yet to find an instance in which someone has violated the criminal laws.
And my other question has to do with the due process. You know, I'm not a lawyer, but when you talk about sort of, you know, nobody's sort of life can be gotten rid of without due process, it strikes me that if a suspect is killed by a police officer, their life is deprived before they get due process in law. Can you describe me how the law kind of squares those instances?
Yes, the due process that is being afforded to the individual that has been killed is by having all of those cases referred to the Office of Special Prosecutions to ensure that any time someone's life is taken, even by a law enforcement officer, we review it to determine whether or not the criminal law was violated. We do that every single time because we believe that the citizens of the state of Alaska deserve that type of review, that type of scrutiny, even of law enforcement actions.
And if I may, just one more, I'm curious about it sounds like a lot of the delays in information getting to the Office of Special Prosecutions to sort of wrap those investigations up are kind of in the purview of the police departments themselves and getting that information. Is there any teeth, for lack of a better word, that the Office of Special Prosecution has to legally compel that? Because it sounds like if a police department just hasn't prioritized sending that review to the Office of Special Prosecutions, the process is stalled. I'm curious if the Office of Special Prosecutions has any method to sort of, rather than request that they speed it up, actually get it sped up.
Yes, I think that there are ways to do that. I think holding press conferences like this one, issuing press releases of when we don't have the information in a timely manner, those are things that we are ethically allowed to say there's a delay in it. We can say the efforts that have been going on, the information that we're still missing. That can bring public pressure to bear on other agencies, on our partners. Our first step, of course, is to communicate with them. We have good working relationships with law enforcement, with the state crime lab, and with the state medical examiner's office. And I would always seek to talk with them first and to encourage them and to come up with processes to help them get information to us faster. I think that will work. I'm very optimistic about that. But if it didn't work, are there other things that can be done? Yes, there are.
Okay, next we're gonna go to the phone, reporters on the phone. Claire Strempel with the Alaska Beacon, you're up next.
Hi, thanks. This is Claire Strempel with the Alaska Beacon. I'm curious, after the Supreme Court grants past ruling, is the state preparing for more frequent escalated police interactions with its unhoused population? And if so, how?
So Claire, I want to make sure I understand the question. You're talking about the U.S. Supreme Court decision that allowed municipalities or states to tell folks that they need to move from the place that they've been staying when they are homeless. Am I correct in that question?
Yes, sir, that's correct.
Okay. So I don't know the answer to that. I imagine that law enforcement is having conversations within their own agencies about how they'll manage those things. I think the question you're asking is really one that's more appropriate to be directed towards the municipality of Anchorage for its government and its police agency, or to the Alaska State Troopers to the extent that they were involved in it. But the Office of Special Prosecutions doesn't get involved in those things. We're just interested in whether or not the use of force would violate criminal law. That's really what our purview is.
Claire, did you have a follow-up?
Yeah, and so it sounds like no preparations have been made in the special prosecutions unit for an influx of cases, so there hasn't been an anticipation of that in the Department of Law.
We're not anticipating an influx of cases. However, we did more than double the number of prosecutors that are going to be handling these types of cases to ensure that we can get those cases reviewed in a timely manner. I don't view that as a response to the case in the Supreme Court. I view that as a need to make sure that these cases get handled in a more timely manner. So I don't anticipate an influx, but I suppose only time will tell.
Okay, up next on the
Thank you.
phone. Thank you, Claire. Up next on the phone from the Juneau Empire, Jazz Garrett or Mark Sabatini? Who will have the question?
This is Jazz Garrett of the Juneau Empire. During the Office of Special Prosecution's final review of a case, what steps are taken to review the credibility of the law enforcement investigation of themselves?
That's a great question. When you talk about the credibility of an entity that investigates itself, you really have to look at how did the entity set up their organization to begin with. Are there steps or efforts taken to separate the officers that are involved in the shooting from the individuals that are actually conducting the investigation? That's the reason that things like body-worn cameras, audio recordings are also critical. The autopsy and the ballistics, all of those different pieces of evidence are the types of things that prosecutors look at for corroboration of statements that are made. And so I think that there are a lot of checks and balances found within an investigation to corroborate within an investigation when the right information has come forward, when it all fits together in the way that it's supposed to, and when it's not. I can also tell you that there are some folks who think that having a different agency investigate makes more sense. And I know that in the lower 48, there are some places that try to do that. In Alaska, that can be particularly challenging given the size and geography of our state to have different agencies investigate. But there are steps that can be taken. We do evaluate statements that are made for credibility, and we do that by comparing it to the other evidence that we have. Thank you for that question.
Okay, back to the room. Johnson, do you have any more questions?
No, I'm good, thank you.
Okay, sorry, Jazz, did you have a question?
I just had a quick follow-up, if that's okay.
Sure, go ahead.
You said that the Office of Special Prosecution will try to have someone on scene when possible, and I was wondering if that happened in Juneau on Monday, if someone from the Office of Special Prosecutions was able to go to the scene.
For the incident that occurred on Monday, we were not able to make that one happen, but there's a number of other pieces of information that will be provided to us that will be helpful. And as I indicated, we try to do that when possible, but it's not always possible. Unfortunately, would we have preferred that? Yes, but it just didn't work out that way for us. So that's the answer.
Are there any other reporters online who've not stepped forward with a question?
This is Mark Sabatini at the Juneau Empire. I'd like to follow up on something.
Go ahead, please.
Yeah, just to follow up on what Jazz asked. You mentioned there's been, of all the investigations conducted since 2009, there were not criminal charges referred in a single one. And I imagine there would be any number of people who would say, wait a minute, how can we have any confidence in the outcome of those investigations if that's the result? And what would be your response to that?
My response to that would be that we are fortunate in the state of Alaska that we have a law enforcement community that is more professional, is better trained, and that we have not had the problems that have existed in the lower 48 where charges have needed to be filed. We have reviewed every single one of those incidences. We have made the letters that we reviewed in those instances public. You've also had indications where you've had the University of Anchorage, Alaska, that has gone back and reviewed some of those cases that we looked at. So it's a second layer of review that's been done. And in each and every instance, when anyone has looked at it, nobody has yet to say that the call that we've made has been inappropriate. So I would tell you that we are fortunate that we have a good system in place, that we are fortunate that we have good people that are employed, but we remain vigilant. We hope that we will never encounter a situation in which officers use lethal force that's in violation of the criminal laws. But to be assured of that, we will continue to review that in each and every instance. And our review has been made public, will continue to be made public, so that the public can have confidence in those decisions that are made.
Mark, did you have a follow-up on that?
No, thank you.
Okay, any other reporters online who haven't had a question yet? Okay, we're gonna go back to the room then. Zach at Daily News.
Thank you. Just you mentioned some of the bottlenecks or some of the delays kind of initiating or finalizing reviews at autopsy and ballistics were two that you mentioned.
Sure.
Are there other stress points that are sort of resource constraints or, I mean, you've increased personnel in OSP to kind of help move things along. and maybe this is a question for the Attorney General, just because it gets into sort of funding and stuff, but are there other resource areas that would help speed this process along, be it, you know, personnel doing ballistics reports or more staff in X, Y, or Z?
I appreciate the question, Zach. Are there stress points? Yes, there are stress points. Ballistics is one of those things that we mentioned. We have one individual in the state crime lab that handles ballistics reports. I can't comment on the workload for that particular person. I think that's something that's best addressed to the state crime lab. We have talked with them about trying to set priorities on certain cases. Officer-involved shootings are going to be cases where priorities need to be set. And we've talked about some of the cases where some of those reports have been delayed. We actually are now expecting or anticipating we are going to get those reports in the next week or two. So I think there have been steps that have made that have been responsive to that. Are there additional resource constraints? I can't answer that question right now, but I can assure you, as one of the individuals that's involved in that stakeholder community, we are ongoing evaluating that. And if we believe that there are additional changes that need to be made, we will either attempt to implement them within the system, or we'll approach the administration and the legislature to request those resources if needed.
Just to clarify, so
Sure.
is there on some, sorry, just to clarify, so on some of the state crime lab work, and some of this forensic work that's happening, is there any prioritization mechanism, or is it all kind of first come, first serve, and you're where you are in the queue?
So in the crime lab, I can't speak for how they prioritize all their cases and all their casework. I can tell you that I have specifically had a conversation with Mr. Canaris, who's the director of the state crime lab, and we have agreed that there will be a prioritization on officer-involved shooting cases, so they will be at the top of the queue. As to how all the other cases get prioritized, that's really a question best directed to Mr. Canaris.
Wes, do you have a question?
Yeah, I wanted to follow up on what Mark had said earlier. I'm curious, you know, I've spoken with attorneys who have represented cases in police-involved shootings, and they've noted that it seems like there's a very high bar for if an officer sort of acts in such a way that would be deemed criminal. I'm curious if you could sort of lay out examples of what sorts of behavior by an officer or activity you think would constitute criminal charges beyond sort of what. I guess I'm curious what falls into the line of duty and what would fall outside of the line of duty that would justify criminal charges being filed.
Yeah, so the answer to your question, Wesley, is not that an officer is acting outside of the line of duty. I think that when an officer arrives on scene and they encounter a situation and discharge the firearm, that's within the line of duty. And it's not a question of were they in the line of duty or not. It's a question of whether or not their conduct was authorized by statute. And to answer that question, I'm going to go back to the statute itself. The use of force, the deadly use of force, is authorized by officers first, if they reasonably believe it's necessary to effectuate an arrest or terminate an escape for a felony against a person. So what would be an example in which that wouldn't happen? If they show up at a scene and they're trying to make an arrest on a misdemeanor, and we're having trouble making that arrest, and ended up using deadly force, and there was nothing else to indicate that the person was endangering life or was about to inflict serious physical injury, that would be a crime. When officers show up on scene, if the individual is not engaged in conduct that is endangering life or creates a risk of serious physical injury to another person, that's what our prosecutors are looking for. But what we have found since 2009 is that when officers arrive on scene and they are confronted with those scenarios, we have found officers are not discharging their firearms unless it was authorized by statute. Now that statute, that's a pretty broad authorization when they're allowed to do that. I'm not making any bones about that. That is a broad authorization. But those are the laws in the state of Alaska, and we haven't found anyone to violate them yet. But I try to give you an example of a situation in which it might occur. Okay?
Yeah, given that we're constrained by time, I just wanted to end with a little statement, if you don't mind, and then we'll conclude this press conference.
Let me speak into the microphone so those online can hear. So the reality is that our duty as the Department of Law is to enforce the law. And of course, part of enforcing the law is following the law. And so you've asked for opinions of us about how we feel about different things. But the reality in the matter is that our opinions really don't matter.
because the law and the Constitution and how it's laid out in statute and how the rules of professional conduct read. Those are the things that constrain us in what we do as prosecutors and as we review these types of cases. So, so that's the main point from today's press conference that I want you to take away, is that it's laid out in the law. We follow that process. Now, if there's people that feel like that process needs to be fixed, then the way to do that is through the legislature, through changing the rules of professional conduct. But as of right now, our duty and our chief concern is to follow that law as it's laid out by the legislature currently and by the courts as they produce those, the Alaska Supreme Court in their rules of professional conduct that we as attorneys have to live by, including, as John pointed out, prosecutors. So I appreciate your attendance today at this press conference. Hopefully it's helpful as you evaluate this and as you report. I appreciate your help in getting this information out to the public as well, because I think it's necessary for people to have confidence in our system, and to the extent that they disagree with how the system is, to be able to articulate how that should be changed and articulate that in a way that can have change. And so thank you again.
Thank you. This concludes the press conference. Thank you.